HB 52. Oh, I'm sorry, HB 52. We are now live streaming. Thank you for bringing that back to my attention. I'm sorry. Yes, we're now live streaming HB 52 and HB 1312. And as we discussed previously, ladies and gentlemen, judiciary is the primary on these two bills. We are secondary. The Judiciary Committee met last evening, and they passed out both of these bills. And as we discussed in our previous meeting, we agreed that the document that you received yesterday, if there was going to be any change, the document based upon judiciary's vote, you would also receive a new version of the bills with the changes from yesterday based upon judiciary's amendments to the bill. And that's what you have in front of you. Or that's what you have. That's what you were given. Whether you have it in front of you or not is a different story altogether. And we're going to go with HB 52 first, obviously, like I said earlier. You were given, yes, sir.
Excuse me, I don't mean to interrupt you, but do you happen to have the judiciary vote on 52 and 1312?
Matthew, do you have the vote on that one? I do not.
Yes, I do. It was, apologize. It was 13-7 for both.
Thank you.
So party line.
Yes.
A little bit.
That'll probably make my discussion a whole lot easier. So, ladies and gentlemen, as indicated, that's what was discussed last evening. HB 52, let me give you a brief description, extends time between the filing of failure to pay rent case in the hearing to 7 days. Currently, it's 5 days. It also requires that before filing a failure to pay rent action, a landlord deliver a certain notice to the tenant. It also requires that a complaint for possession filed in accordance with the failure to pay rent law shall include a statement that affirms and states the date that the landlord delivered the notice required by this act. It also requires a tenant to authorizes a tenant to challenge assertions made by the landlord with regard to delivery of the notice. It also requires surrender of the premises within 7 days following the court order in a failure to pay rent action. And that has been changed from current law is 4 days, and now in this bill, it's 7 days. The bill also, as amended, also authorizes a court to order an emergency stay of execution of a certain warrant on a motion presenting evidence that the eviction of the tenant would endanger the health or life of the tenant or any other occupant of the premises. And the amendments also make additional clarifying changes. Now, because we as a subcommittee have not discussed and or adopted any of these amendments previously, we have this bill as amended before us right now. The bill, as I indicated, was amended by judiciary and given to us in its present form that we have in front of us. I am asking for a motion to move the bill as amended. Is there a second?
Well, actually, don't we have to adopt the amendment first and then?
Well, if we got
Oh,
yes,
you're right. It's as amended. You're right.
we have not amended the bill, so we have a bill as amended from judiciary. So our motion, I think, and I'm definitely open to suggestions. Our amendment would be to move the bill as amended from judiciary, period. I think.
That makes sense.
Because we have not voted on anything. So we have before us right now a bill as amended.
From judiciary.
From judiciary. I see the hands. Hang on a second.
So
I want to get a clarification on the motion first before I go to questions. Mr. Chair.
I think we have to amend the bill. We have the bill in our possession as it was introduced, even
That's
though
correct.
it's secondary. I think we have to adopt the Judiciary Committee amendments, and then we'll have the bill before us as amended by the Judiciary Committee.
Okay.
Procedure.
Wonderful.
And so I'd like to move the Judiciary Committee amendments.
Second. Any discussion on the amendments? Delegate Lehman.
Yeah, so then if we vote on the amended bill out of judiciary, then do we have an opportunity to discuss concerns or further changes to the bill?
On the whole, yes, we can discuss it. Yes, we can discuss it.
Okay,
So right now we're on, I'm sorry, I didn't cut you off.
okay, okay, just
We're-
even if we're potentially going to ask to amend a judiciary amendment, even slightly, we can do that after we
Well, I
adopt
think
the
as a matter of procedure, I think the simplest thing to do would be to adopt the Judiciary Committee amendments and then discuss what remains.
That's correct. And right now we're discussing amendments. I'm sorry, Delegate Lehman, are you complete with your question?
I'm fine.
Delegate Healy?
Thank you very much. I do have questions about the amendments, about this change from the number of days, from 3 to 4 to from 4 to 7, whatever that, all
Yes.
of that. Are we talking about calendar days, business days?
Good point. And the reason in all of real estate law, whenever you talk about days, it's always calendar days. It's
So
never
you have-
business.
I'm sorry.
It's never
Go ahead.
business days. It's always calendar days. So whenever you see the word day or days, it's always calendar days. And the reason why we went from 4 to 7 is because if something takes place on a Friday, for example, if it's 4 days, you have Friday, Saturday, Sunday, and that means you only have 1 day to act. That's why it went from 4 days to 7 days, because it's all calendar days.
Okay, so then the question becomes, I mean, that explains that piece. But the question then becomes, is 7 days enough if you have like Thanksgiving holiday, people have Friday off, Thursday, Friday, Saturday, Sunday. I guess you still have, if you make it 7 days, you still have a few more days to go, right?
That is correct. And that was a lengthy discussion in arriving at 4 days. We have had meetings on this last Friday, last Saturday, and Sunday, and Monday, and the decision we came to was 7 days.
Okay, thank you. I appreciate that.
Okay. Any additional discussion on the amendments? Seeing none, all in favor of the amendment, signify by saying aye.
Aye.
Opposed, no. Any abstentions? Fantastic. The bill before us is amended. Is there a motion on the bill as amended?
I move favorable.
I second. Is a discussion on the bill as amended? Delegate Lehman?
Okay, so again, if we're going to move favorable right now and the bill is amended, does that preclude us from offering our own amendments? Are you you're moving to adopt the judiciary?
Well, procedurally speaking, you can still offer amendments, just as in the committee when a subcommittee chair says move favorable with amendments, people still are free to offer amendments. I personally am going to argue.
But we already adopted, we adopted.
No, you're free to offer additional amendments.
Right
Here,
now, before we
Yes.
vote?
Yes.
Because that's what I have a specific provision that I'm concerned about.
I have a quick procedural question.
Well, do you want me to read it now?
Well, hang on, Delegate Lehman. In the process, if there's a call for a procedural question, that takes precedent in the rules of order. So, and Delegate Fraser-Doggo has a procedural question. Then we'll get back to you, Delegate Lehman.
Okay, and it's just because we're talking about the procedure. So my question is, if we adopt an amendment if we do an amendment and we adopt an amendment, will that bill then have to go back to judiciary?
You are
to be
correct.
voted on again?
You are correct.
Yeah. Yeah, because the bill that goes to the House floor has to be agreed to by both
Right.
committees.
Just like if it was on the Senate, it'd have to be exact.
I mean,
That's
it's like the case of the bag bill where the Economic Matters Committee added an amendment and we had to agree to that before the work product went to the House floor.
That's what I thought. I just wanted to clarify.
Okay.
Thank you.
So now let me get back to Delegate Lehman because she has a question.
So I think I'm asking a procedural question. I'm concerned that if we adopt the amended bill from judiciary, then we're closing the door to to ENT amendments.
You can
Well-
offer an amendment, Delegate Lehman.
Yes, you can
Before
offer
the
an
vote?
amendment. You can offer an amendment now or in committee. Yeah,
Okay, I'd
I
like
mean,
to
we're not,
offer, yeah, I'd like to offer something now. I have a question/concern. I don't think it's major, but I think it's something that needs to be addressed. Do you want me to say what it is now then?
Yes.
Sure, go ahead. You have
Okay. So I don't have the bill, and I don't know if page numbers have changed from judiciary's work last night, but I believe this is on page 8, and it's a reference to the Maryland Legal Services Corporation, which has been substituted as a source of sort of financial and legal assistance for renters. And my understanding is MLSC is not that kind of organization. It's a grant organization that makes money available to legal services and financial services organizations that in turn help renters. So I believe that needs to be tweaked, to say, and I think MLSC has agreed to be sort of a point of contact, but that they would then refer renters that contact them to other financial and legal services entities that can in fact help. And I think there was acceptable language in there. I'm not sure why judiciary struck that, but it's just not, it might not be catastrophic, but MLSC is not that type of organization. They're a grant organization.
And as I understand it, MLSC, you may be correct in that they don't provide specific services, but they
Right.
do, but they are in fact, they can direct people in terms of where those services are available, which is why the judiciary put them in place as opposed to the other organizations. And your amendment would take MLSC out and put whom in its place?
Would either, revert to what the language before judiciary struck it. They apparently don't even have have staff that can make referrals. That's not the type of animal this organization is.
So your amendment will remove MLSC and replace it with what?
I'm sorry, what?
Your amendment will remove MLSC and replace it with what?
Well, to go back to, again, I don't have the either reprinted bill or the way judiciary did the amendment. I think it was more, sort of accurate or useful the way, my understanding is the way it was originally before MLSC became a substitute for and the other organizations were not named. They were not, named by name, these other entities that can provide rental and legal assistance to tenants.
Well, well, let me say this, Doug, leaving very respectfully. I'm attempting to move the bill, and I think that in absence of you having an amendment for us to review, I'd like to move without a verbal amendment from you, and perhaps you can offer a written amendment at a later point. But I would like to move this as quickly as possible if I could, specifically if there's no written amendment.
I can recommend language if you can give me either a couple minutes, unless Delegate Barve, I haven't seen, you're the chair, Mr. Chair, but I haven't seen too many instances where we do amendments in full committee.
Well, we just did one HB
I know,
313 this morning. But
And I know you don't want it coming back to this subcommittee. We don't want this back and forth between us and judiciary.
So are you making a motion, Delegate Lehman, for an amendment? Is that what your motion is? And I don't know how to. What is your motion, Delegate Lehman?
I would like to make a motion, but I don't have specific language already. I would need a couple of minutes to go to either look back and see if we could just reinsert the language judiciary struck. I was trying to print out right before we started the hard copy of the bill itself, but I didn't get a chance to do that. It's 19 or 20 pages long, and I was attempting only to print pages 8 through 10, and my printer was not being cooperative, so I do apologize. I did not.
All right, let me see if I can help you out, Delegate Lehman. Let me see if I can help you out.
Uh,
All right, let me see, Delegate Lehman, let me see if I can help you out.
okay,
What you are suggesting, Delegate Lehman, is to remove Maryland Legal Services Corporation and insert a service provider. That is your amendment, Delegate Lehman, as
it
I
would be a
recall.
simple amendment to put it back how it was, strike the reference to MLSC, strike it. And
Yeah,
then legal
I
services.
understand, Delegate Lehman. That's what I just said. So you're striking MLSC and
Yes.
and you're inserting that is your amendment. All right,
Yes.
that is the amendment by
Yes.
Delegate Lehman. And,
Yes, Mr.
and
Chairman.
I hear your amendment. I'm going to resist the amendment, Delegate Lehman, but is there a second on the amendment?
Second.
There's a motion and a second. I see hands up. I'm going to go in order. Delegate Barve.
Yeah, I'm going to oppose any changes, especially to this language, because my understanding is that references to Maryland Legal Services Corporation was at the request of the chairman of the Judiciary Committee. Now, you know, let me just say that I tried to get this bill into our committee because I felt the subject matter really belonged in E&T, but I wasn't successful. It can be very, very, frustrating when you have two committees that might disagree on some details, as may be the case in this instance. But I want to keep this bill moving. It's not everything that I'm sure the sponsor wanted, but to a very great extent, this has taken care of a lot of the concerns of a lot of the rental advocates, the way the bill is written right now. And so I'm personally going to vote against any attempt to certainly to amend the MLSC language from the bill. That's.
Thank you, Mr. Chairman. On the amendment, Delegate Wells.
No, my hand's raised on a different matter.
Thank you very much. On the amendment, Delegate Terrassa.
Yeah, I'm not completely clear. I apologize, but I'm still not completely clear, and I'm also in two meetings, so I apologize. But this is to strike this and put in legal services. Like it sounded like you, Mr. Chairman, was saying.
Let me be very specific in terms of what Delegate Lehman's amendment is. Very specifically, Delegate Lehman's amendment is to strike Maryland Legal Services Corporation, and instead of Maryland Legal Services Corporation, she wants to insert a service provider. That is her amendment.
This is what
Okay,
I'm attempting to do. I don't think it's.
Hang on a second. Hang on a second. Let me finish with Delegate Terrassa.
I thought I heard her saying something slightly different, but maybe I was confused. Okay, so, but I'm still confused about what happens then. Then does the whole bill go back or just the amendments go back? Because I guess what I'm trying to figure out is how this works. You know,
Well,
I agree with Chairman Barve that it's frustrating because, you know, even if we want to fix small things, it's kind of.
Well, just procedurally, whatever bill goes to the floor has to be voted on in exactly the same form by both committees. That's
Yeah.
That's right. So are you complete, Delegate Terrassa, so I can?
Mr.
Well,
Chairman,
I mean, I guess to be.
Delegate Lehman, hang on, let me finish with Delegate Terrassa. Delegate Terrassa, are you finished? Delegate Terrassa?
No, I guess I'd just like to, I don't know. I mean, I guess I'd like to just go through what the concerns are, because, I mean, I'd heard a couple of concerns, but I'm concerned about it then getting stuck and going back and forth, and that is concerning.
As am I. Delegate Lehman, you're next, and then we're going to go to Delegate Healy.
Mr. Chairman, Chair Holmes, I'm going to go ahead and withdraw the amendment. I'll let MLSC make its case that it is not that type of entity. I'm just going to withdraw the amendment.
Thank you very much. Delegate Healy on the amendment.
Thank you very much. Since the amendment's been withdrawn, I don't have a whole lot to say about it, except that I was going to say that we do have, there will be opportunities because this bill has to go also through the state Senate. And there will be opportunities to put amendments on in the Senate. And sorted out if there is a problem. My understanding of MLSC is that, yes, they are mostly a grant making, but they sometimes create programs which they fund and which the local legal services groups can participate in. So but be that as it may, I think there's time to get this fixed somewhere else, and rather than jeopardize the bill, I'm glad that it's been withdrawn.
Thank you so much. I still see hands up from Delegate Lehman, Delegate Wells, and Delegate Healy. Do any of you still have questions on the amendment, which has been withdrawn? Thank you very much. Any others? So the amendments are before us. They have been motioned and seconded. All the amendments, Delegate Wells.
Can I just raise this before?
Sure.
So
I guess you're allowed since your name is on the bill.
I appreciate the courtesy, Mr. Chair. I just wanted to raise the one thing because I do believe that, and however we can address it, right? Because I understand that we are up against a very intense time constraint, both today and also with crossover. But I do want to say though that there's one thing I think that would be important to address, and it's just clarifying that the notice of delinquency is sent once you are delinquent on your rent, right? So if it's if a entity has a grace period in the lease or in the local law, then late would mean the day after the expiration of the grace period. And if it's not listed, then it would just be the day after the rent is due. So if it's the first of the month, then it would be late. Notice of delinquency would be sent on the 2nd. So I just want to raise that because I do believe that really actually clarifying that language, I believe really does speak to the intent of this bill. And I think the intent of what leadership and other folks are seeking to accomplish with this bill in terms of having a process that's clear. So I just want to put that out there, Mr. Chair and Mr. Chair Barve. I don't know how we can address that, but I think it is really, really important to address before we finish this process. Not today, in general.
Thank you, Delegate Wells. Delegate Barve.
Yeah, let me say that that may be a meritorious concern, but let me say that we're going to be voting as a committee at 4:30, and here's what I think we should do. I think we should have the staff council take the interim time to look at that. And if this is in fact, I'm not a lawyer, so I can't really parse the language quickly the way Matt can probably while juggling and drinking a milkshake. So, I think maybe we should have him look at the language between now and when we vote as a full committee. And if this is a real problem, then it would have to be something that we would have to address. But I can't for right now myself. I don't feel confident saying that it's right or wrong at this point.
Thank you, Mr. Chair. Delegate Teresa, your hand is still up, and Delegate Wells, your hand is still up. Are there still questions on the amendments?
It's a concern. I guess I don't know if it's an amendment or not. It's a question, another concern that was raised, but I'm not 100% positive I understand it, but I just wanted to raise it as well.
Okay.
And I believe and I'm trying to find the information. I apologize. I was supposed to be testifying HGO, but they just took a break. My understanding is there was a record keeping requirement in 8208. So this is on page 4 of the bill. There was a record keeping requirement showing the dates of the rent paid for the landlord and tenant, showing the fact of it's section 82083A on line number 5. And I'm not sure why they crossed that whole section out, but it looks like they crossed out the existing section as well.
So there's not a function paragraph that would repeal that law, so they're just striking from the bill.
They're just striking from
they're striking that whole section from the bill, but it's not repealing existing law. Because when the language is pulled in, it's repealed and reenacted with amendment. So it's without a function paragraph to repeal that language from existing law added in up on page, it would be out on page 2 here. It wouldn't pull anything out of existing law. That's the proper drafting technique if you were intending to strike all the changes in the full section.
Okay, maybe I'm just misreading that. I'm not sure I understand why. Then I guess it's just a policy question of why they are striking that then. As long as they're not taking that out of 8208.3. I understand what you're saying.
Yep, they're not taking anything out of existing law.
Thank you, Matthew.
Okay,
Any additional concerns? Delegate Trassa?
don't think so at this time.
Thanks so much. Ladies and gentlemen, we have before us a motion for the amendments, and there's a second. Any additional discussion on the amendments to HB 52? Hearing none, all in favor of the amendments on HB 52 signify by saying aye.
Aye.
All opposed say no. Any abstentions? The ayes have it. Move the bill move HB 52 as amended. Is there a second?
Second.
Second. Any discussion on HB 52 as amended? Seeing none, all in favor of HB 52 as amended signify by saying aye.
Aye.
All
Aye.
opposed say no.
No.
We have Delegate Wyvo and Delegate Parrott.
And Silberti.
And Delegate Siliberti. Delegate Siliberti, you have three. Wyvo, Parrott, and Siliberti. Thank you, ladies and gentlemen, for your indulgence. Now we'll next move on to HB 1312. HB 1312 was distributed to all of us yesterday, I believe, or day before yesterday, whenever we had our last or previous Housing Real Property Subcommittee. Judiciary did not make any changes to what we received at our last meeting. So what we received at our last meeting is exactly what was approved by Judiciary Committee last night. And brief description, the bill requires the judiciary, as opposed to the sheriffs, to collect, compile, maintain, publish bi-weekly on the judiciary website data on evictions, and requires an annual report on evictions data to the governor and the General Assembly, with the first report due on August 31st, 2022. It also codifies the governor's executive order and applies it whenever a catastrophic health emergency is designated. The bill also applies the conditions of the governor's executive order as adopted into law by this act for 3 months after the executive order that lasts for 60 days to 179 days consecutively, and for 6 months after the end of an executive order that lasts 180 days. It also, the protection would apply in a failure to pay rent and a breach of lease cases. Also, the bill provides a term, during the term of the executive or the landlord may not increase the rent payment of a tenant, charge the tenant a fine or a fee for non-payment of the late fee or rent, including late fees, administrative fees related to rent, collection fees, court costs, or liquidated or other damages of non-payment of rent. That is what the bill does with the amendments, ladies and gentlemen. And as I indicated, what we are voting on today is exactly the same that was distributed yesterday or the day before. Move the amendments. Is there a second?
Second.
Is any discussion on the amendments to HB 1312? Hearing none, I call for a vote. All in favor of HB 1312 signify by saying aye.
Wait, we have to
Aye.
vote on the amendments first.
Oh, I'm sorry. You're right. I'm skipping the gun. Since I'm under the gun, I'm skipping the gun. All in favor of the amendments of HB 1312 signify by saying, oh, I'm sorry, Delegate Wyville has your hand up. Oh.
No, not on the amendments.
Okay, all in favor of the amendment signify by saying aye.
Aye.
Opposed, no. Any abstentions? The ayes have it. Move the bill as amended. Is there a second?
Second.
Discussion on the bill as amended. Delegate Wyville.
Thank you. So the fiscal note, this had it as a 1.4 million annual fiscal note. Is that still the case with the amendments? Do we have an updated fiscal note, or is it still the same?
I have not seen an updated fiscal note. Matthew, can you shed some light on this, please?
I have not seen it. I've not seen an updated fiscal note. Let me just quickly skim, because a number of things were pulled from the bill, which may impact the fiscal note.
While you're looking, Matthew, let me go to Delegate Barve.
Yeah, I think, of course, we don't have an updated fiscal note, but a lot was stripped out of this bill by the Judiciary Committee. So I'm not going to say that it's dirt cheap now, Will, but a lot was taken out of the bill.
So, sorry, I don't mean to interrupt. I will note that some of the fiscal note mentions general fund expenditures increase in future years to reflect continued staffing needs and costs associated with the newly established Maryland Rent Relief Fund. That fund was stricken from the bill, so that will obviously have the effect of bringing the fiscal note down, and the associated grant program. So yeah, because that was all struck from the bill, then that would have the effect of bringing the fiscal note down.
Delegate Barve.
Yeah, let me say that one of the things about this bill that I think is long overdue is the data reporting.
Yep.
You know, one of the things I would like to know for future years is how many people are taking 2, 3, or 4 bites at the apple. I'd like to know how many of the people who've had evictions filed against them are frequent flyers. I mean, for lack of a better term, I think that's important information for our committee to have if we are to make good public policy in this. And those things might cost money. And if they do, I actually think it's worth spending the money to get that information. But, you know, I'm not going to pretend to say that I have a complete understanding of what these changes do to the fiscal note. I don't want to mislead anyone.
Thank you, Delegate Barber. And there was significant discussion in that particular item all by itself in terms of how the data is collected when the sheriffs go out to oversee the evictions. It was at one point during the discussion discussed that we should probably have the sheriff's department do it. But then based upon what we finally wound up with, it is now the judiciary. Delegate Healy.
Yeah, I just a quick question, because I looked at the bill. There's so much been taken out of it that I'm not totally 100% clear about what's left. I know you explained it, but I just wondered, is the judiciary willing to accept that? Are they going to be dragged, you know, kicking and screaming into doing this new work?
Kicking and screaming.
My understanding is that there's been discussions with the judiciary about the reporting requirements, and that everybody is on board, or that there's an agreement.
Okay.
And this is data that otherwise is being received by the judiciary on evictions that have been processed.
Okay. If you could, is it fair to say that this bill has been turned into something that's gathering information and it no longer has all those other provisions? All that's left now is that they're collecting information so that we can make good decisions in the future?
Well, that's not, so go ahead, Matthew.
Well, no, go ahead, Delegate Holmes.
I said that's not all that it does. As indicated previously, the landlord cannot charge the landlord cannot increase the rent for a certain period of time. The landlord can't charge.
And that's during the catastrophic health event.
That's right.
Oh, yeah. Aside from the catastrophic issues.
Oh,
yeah.
no. Then you are correct, then, Delegate Healy.
Okay, thank you very much.
All right, I'm sorry. Yeah.
It was
Any
my fault.
addition-
I didn't say that part.
Any additional questions? Any questions on the amendments? Hearing none, we have a motion and a second on the amendments. All in favor, signify by saying aye.
Aye.
Opposed, no. Any abstentions on the amendments? One abstention or objection, Neil?
I'm sorry, that'll be on the actual bill itself.
That's what I thought. You can, well, your hand is getting awfully. The amendments passed. We're now moving the bill as amended. Is there a second?
Second.
Sure. Well, hold on, Earl, wait a second.
I'm sorry? What?
Sorry.
I'm sorry.
I think it was somebody talking on the phone.
Yeah. So the bill is before us as amended. There's a motion and a second. Any discussion on the bill as amended? Seeing none, all in favor of HB 1312 as amended, signify by saying aye.
Aye.
All opposed? Now, Mr. Perry.
Oh,
Okay, so opposition of the bill is Delegate Wival, Delegate Parrott, and Delegate Siliberti. Ladies and gentlemen, I appreciate your time, and I'm sorry for rushing through this, but I think it was necessary to get us to the next step. Thank you very much for your patience with me, and I appreciate it. And Delegate Wells, thank you so much for your participation. Take care.
Okay,